There is literally a mall in Lowell that is half in Massachusetts, half in New Hampshire, or somewhere up there. But
right. Just don't go to the food court with your gun, I guess. You'll be in Massachusetts and you're in a lot of trouble.
What possession actually means. So they have to prove 3 things for possession. They have to prove knowledge, dominion, and control. So you might notice dominion and control, I think, are synonyms. But
it
actually means where even though this guy was carrying this bag with a gun in it, we're able to show them that, hey, he may not have known that there was a gun in there. It may have belonged to the guy whose ID was in the bag.
All right, welcome back to another episode of Boston Barristers. This is episode 9. We're here with Matthew Peterson. I'm Chris O'Brien, and today we're going to talk about gun cases in Massachusetts. It's a topic that will never be boring, and we're talking today to someone who is as much an expert in trying these cases, I think, as anyone could be. In terms of background, Matthew, I can let you introduce yourself to the audience if you want, but I think the big part of this podcast for me is that you had 2 jury trials last month, both of them gun cases, both of them acquittals. Varying degrees of difficulty, but I think the level of lawyering is probably what eked out the victories in the end. And I think we obviously want to talk about those cases, but welcome to the podcast.
Thanks, Chris. It's always good to be here with you and always good to see you, man.
Yeah. So I think maybe the first place to start, because I think that our audience is probably going to be familiar with the fact that gun laws in Massachusetts are among the most strict in the entire nation, right? And the courts have been slow to adopt the federal protections, Second Amendment rights that the federal courts have been moving towards in the past decade or so. And we deal with this, obviously in license to carry and stuff like that. You've had plenty of experience in that. But what I want to ask you first is, what are the stakes? Because of these strict gun laws, what would you say are the stakes for someone who gets caught up in the criminal justice system when it comes to gun charges?
So yeah, gun charges are some of the highest penalties in Massachusetts, and we have some of the most strict gun laws in the country. If you are caught with a gun outside of your home or business without a license to carry in Massachusetts, you are facing 18 months mandatory minimum. That's day for day in jail.
Yeah, I got to know what that means. Can a judge suspend it? Can it be something I could do? I just tell the judge I'm a real nice person and this was an accident. I mean, is there any discretion at all?
No, like if Mother Teresa got caught with a gun in Massachusetts and she got convicted, it would be 18 months. The judge cannot help you with that 18 months. It's day for day in jail. I mean, it's absolutely ridiculous. Like, I mean, when I worked in Alabama, there was a misdemeanor having a gun without a license. In some states, it's not even a crime. You don't even have to have a license. In Massachusetts, 18 months. And the only real saving grace is if you can go to the DA and convince them to reduce the charges. And that depends on the county.
What is the chances of that happening?
So in some counties, it's close to 0. In other counties, it can be a lot better. Like in Suffolk right now, the policy, this is September 2025. In a lot of these cases where you have someone from out of state, they'll actually work with you and not even arraign the case, dismiss it prior to arraignment. If you have a license out of state. Whereas if you are a few miles north in, say, Lynn in Essex County, you could be looking at 18 months mandatory minimum, and you would have to beg the DA to give you a misdemeanor and probation and a conviction. So, yeah, I mean, that's if you are, dead to rights guilty on the case. So, yeah, we have some of and that's only the gun. I mean, if you're talking about high capacity magazine, if you're talking about, have a prior record, like ACC, the penalties go up very quickly.
So I feel like the thing that you just pointed out about Lynn is worth kind of drilling down on, because if you're just a bit to the north, Essex County borders New Hampshire. And I was a prosecutor in New Hampshire for a number of years. The gun laws in New Hampshire are all but non-existent now, right? They're still governed by federal law. So it's hard to get a gun if you're a felon or if you have certain domestic violence convictions. But by and large, you can get high capacity weapons. You can get stuff that's not legal in Massachusetts. And then you could what you're telling me is that could basically just happen over the border from New Hampshire to Massachusetts. And if I am found in possession of a firearm, I'm going to do 18 months.
Yeah. I mean, and assuming you can't beat the charge or convince the DA to reduce the charges, I mean, there is literally a mall in Lowell that is half in Massachusetts, half in New Hampshire. or somewhere up there. But
right. Just don't go to the food court with your gun, I guess. You'll be in Massachusetts, you're in a lot of trouble.
Today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show.
So you mentioned if you can beat it. And I guess one of the things that I can understand, having worked as a prosecutor now as a defense attorney, is that when you have something like this, if you have a DA who's not going to break down the charge and you've got this mandatory, a lot of times it just the only option is to go to trial, right? And is that something that you've encountered in your practice?
Yeah, I mean, so generally there's a series of steps that I go through in a gun case to see what our possible defenses are and what our possible ways around it are. But a lot of times in these last two cases I tried, trial is the last option. And you got a lot of different ways you can get around it.
So walk me through, the sort of various elements, right? Because we've talked about if you're found having a gun, what does that generally mean? I know there's kind of complicated issues about safe storage, laws that govern that. But can you speak to your experience with improper storage charges, possession charges? I don't know if you want to get into constructive possession. That might be, if people are thinking, I have a gun in my trunk when I drive here from, between New Hampshire and Connecticut, like what's, I don't know where you want to dive in on elements, but.
Yeah. So possession, the jury instructions, if you read what the judge tells the jury is that there's possession obviously on you, like you have it in your pocket. And then there's what they call constructive possession, which means that you don't have it on you, but you still possess it. The example they always give in jury instructions is you possess something in your dresser drawer at home, you possess something in your safe deposit box at the bank, things like that. So even though you don't physically have it, you still possess it. Like if you had a pen in your pocket and then you pulled it out and dropped it, that would be constructive possession.
I know that one all too well, frankly, from my time prosecuting drug cases in New Hampshire. So then talk to us just briefly, because we've kind of covered the elements of possession and of constructive possession sort of really loosely. But what's the issue that we see sometimes in Massachusetts with large capacity charges? Is that a 10M?
Yeah, I think 10M is the statute. So anything that can carry over 10 rounds constitutes a large capacity in Massachusetts. And that actually it's one of the worst written statutes out there. It actually has a 1-year mandatory minimum, but it seems to actually be somewhere, 2 years, 2.5, something like that, where the statute actually says 2 years, but 1 year has to be served or something like that.
I researched this for a potential client not long ago, and if I remember correctly, just to kind of throw my 2 cents in there, the courts have recognized the sort of insanity of this, but the 10M has, I think, as 10A, which is possession, right? If you have a gun that is a large capacity firearm, having a gun is a lesser included offense. The large capacity is a more advanced charge, and it's got a 1-year mandatory, and then the possession is 18 months. So the lesser included carries a harsher sentence. It's a kind of a good example of how the law is sort of a patchwork, right? And we're not going to talk about the 2024 overhaul, but like they've tried to fix it, but they haven't fixed everything. And it's sort of still kind of a mishmash. And it really does leave people like, this is the thing that blows people's minds. You could there's no sign at the border that says, leave your gun here.
Right. And so that's one thing that I did notice. And this is something we can talk about. Is that if you drive into New York, they do have a sign that says, hey, don't bring your gun here. And if you drive from New Hampshire to Massachusetts, like around the 4th of July, around New Year's, you see signs that say no fireworks. But guns, they just figure, hey, we don't need a sign for that. We just have the cute little books that tell you what town you're in.
Yeah.
So let's go into like what possession actually means. So they have to prove three things for possession. Like they have to prove knowledge, dominion, and control. So you might notice dominion and control, I think, are synonyms, but
It sounds
they actually
similar.
mean something. So you have to know that there's a gun there. You have to have the ability to exercise control over it. It basically has to be in your reaching area, and you have to have the intent to exercise control over it. So intent is obviously a very vague notion that can't be directly proven. Like obviously police aren't often going to have someone say, yes, I intend to exercise that control. So it's a very vague thing about what possession actually means in that situation.
It's the kind of thing that like you can make a lot of hay out of at a trial if, and I think we'll probably get to this later, if it's not something that they can prove by inference that someone had either, again, knowledge, because you're never going to get a mind reader on a jury. We used to say that. If you have a mind reader, so you're going to have to infer from context clues whether somebody knew that they had a gun on their person, as crazy as that sounds, and whether they intended to exercise control over it. I do think that it's going to take it out of the abstract, and we go over an example like the one that you had recently go to trial. But before we get all the way to trial, is it worth talking about how if you get a client who's caught a charge like this, where do you start? Like where does your brain go first when you say, okay, my client has been arrested and charged with possession of a firearm? It's the first thing you do.
So generally the first thing I look at is what they call suppression, which is that you look at whether there was an illegal search that caused them to find the gun. A lot of times this is your first line of defense in these sorts of cases, is to see, did the police search your car illegally? Did they stop you illegally? Did they search your house illegally? How did they find the gun? Is there any legal problems with that? There's also constitutional issues that are potentially out there that we can talk about later as well. It's not as simple as shall not be infringed, Second Amendment. I have a gun, I have the right to have a gun. That argument, unfortunately, does not work in Massachusetts courts. But there are other things, like there's the series of cases we talked about last time about, if you could have applied for an LTC, but the law didn't allow you to, you could potentially have a constitutional issue. But suppression is generally the first line of defense when it comes to these sort of charges.
And I think this it's fairly obvious for us who have litigated things like this for years, but people will know from common knowledge that the fruit of the poisonous tree is kind of like a term people are familiar with. So if you were able to establish with a judge, and this is just, again, because I don't know that it's this perfectly obvious to folks, where Matthew's talking about identifying a suppression issue, he's going to flag that for the court, get into a hearing, and he's going to cross-examine the police officers who are involved in this. And if it is determined that and there are more grounds for suppression that are probably worth getting into in a podcast like this. I mean, we could do a whole separate podcast on grounds for suppression for traffic stops alone. But if you are able to undermine, for example, the justification of a stop, or show somehow that the seizure of the firearm, the discovery of the firearm was illegal, the fruit of the poisonous tree generally is like, we call it the exclusionary rule, right? But it's like the fact that they found the gun doesn't matter, because the way they found it was unconstitutional, and so it's going to get suppressed. The golden ticket in this case is it's a dispositive suppression issue, because and sometimes the judge will ask, is this dispositive? And the prosecutor's going to know from jump, if it's a dispositive motion, they lose this motion, they lose the gun, case goes away. And there really is that's it. Like, there is no way they can prosecute the case. That's not a practical thing. That's like the judge understands it's over. You understand it's over, it's getting dismissed, which is why it's a great first line of defense if, I think, as you would point out, it's worthwhile to get in there and hear what the officers did. Because a lot of times stuff comes out that's not in the police report if you have a good enough attorney to cross-examine them on that.
Exactly. Yeah. So suppression is, you look at, if it's a car stop, for example, do they have proper reason to stop the car? Do they have proper reason for the exit order? So like asking somebody to get out of the car. Do they have proper reason to search the car? So how do they find the gun in the car? Things like that. And then if it's a stop of the person, like, do they have a proper reason to stop you walking down the street? Reasonable suspicion. And did they have a proper reason to search you? So what they call a Terry pat. Did they have proof or evidence that you were armed and dangerous to be able to do what they call a Terry pat, which is a protective sweep of your exterior clothing? So all of those things are things you want to look at initially in terms of we want to file a motion to suppress. We want to get into court and argue that the police searched you illegally. Because at that point, you're kind of talking about it from the prosecutor's perspective. From our perspective, if we win that hearing, then it's over and we still have the chance to go to trial afterwards. But you want to look at all of those constitutional issues like Fourth Amendment and the Massachusetts Declaration of Rights equivalents to determine whether the search itself was legal. And like we could sit here talking about thousands of different scenarios.
Right. But maybe we can limit it to two. One thing I want to clear up is I think you were saying as I was listening, if the defense prevails on a motion to suppress, case goes away. If you lose the motion to suppress, it doesn't prejudice you in any way, right? Like you still can try that, you can go forwards on motions to dismiss, you can do motions to eliminate to prepare for the trial. There's a huge amount of litigation, and you don't prejudice your case by trying a suppression. So it's one of those things you kind of like really should do it if you have a good faith basis for making the argument, because you're not going to lose anything. You only stand to gain. Do you want to talk about specific examples? I know you had Somerville, and I think was it also Boston, where you prevailed on suppression motions in the last, what was it, calendar year or so?
Yeah, so we have the full stories on our website as far as the blogs go, but to put this like in concrete terms, I'll talk about the Somerville case. The guy was from New Hampshire. He ran out of gas on the side of the road, fell asleep waiting for his friend to get there. State trooper comes up, knocks on his window, and then immediately opens his car door. And when he opens the car door, he sees supposedly what he thought was drugs. So he asks the guy to get out, and when the guy gets out, he sees the gun next to the person. So when you're analyzing a situation like this, you want to see, was he stopped? And did the officers exceed the limits of their reason for the stop when they got him out of the car, when they knocked on his window, when they opened the door? And in that case, what our argument is that there's something called the community caretaking exception. And I mean, we could get really into the weeds here, but it's that officers, if they see someone on the side of the road, they can go up and make sure everyone's okay. In this case, the officers went up, knocked on his window, and immediately opened the door, which, if you look at the test, is this a reasonable thing to do? Like, and if I went up to somebody in a car and just started opening their door, I mean, they'd say, hey, what are you doing? You're invading my privacy. And that's what the judge found here, is that actually opening the door, not giving him a chance to wake up, not giving him a chance to respond or explain anything, that led to everything else. It led to the exit order, led to the discovery of the drugs, led to the discovery of the gun. That initial opening the door without giving him a chance to explain himself violated his right to privacy and meant that everything after that should be suppressed.
So I think I've worked on this with you a little bit. And two things I would draw out. You said, was he stopped? And I don't know if our listeners would know that you mean that in a legal sense, right? Obviously, if your car is stopped because you ran out of gas, you are physically stopped. But when the police approach, at what point are you considered to have been stopped by law enforcement? And these things, I mean, it sounds crazy, but these things matter because these are details that matter to a judge, because a judge is looking at case law. And then the other thing I wanted to draw out of this was, as I remember, the police report does not make it at all clear that he basically like knocked and opened. But you got that out of him in the suppression hearing, right? You're cross-examining him and you've understood that this could be the make or break points. You pulled it out of him. And then, as you pointed out, the judge picked on that as kind of the basis, right? Like this goes beyond community caretaking. But there's a lot of fairly advanced like litigation that goes into this, because you had other details you had found in the police report or in the body cam footage that you'd watched. Stuff that's not going to be in the police report, but if you pay enough attention, you say, as they approach the car, they make comments, right, that show that what they want to do is investigate. They're not here to check to see if he's okay. So they're trying to say, it's community caretaking. And you're like, well, not according to everything else that's going on here. And then the way you behave isn't community caretaking. So this is like for being a kind of first line of defense, it's pretty involved. I think you would probably agree. It's a lot of work that goes into it.
Yeah. So like a stop in the legal sense means that you weren't free to leave and the police, asserted some level of force to prevent you from leaving. So in Massachusetts, like a police officer turning on his lights can be considered a stop. Police officer telling you to stop, a police officer approaching you can be considered a stop. Obviously, we could get way into the weeds here, but yeah, one thing about that case is that the body cam, what the state trooper had, was just a gold mine for us. It showed showed us that this officer said to another officer, I saw that out-of-state plate and I knew that this car wasn't legal. And also that they looked at the drugs up close and they could not figure out what kind of drugs they were. So how could he, looking in a split second across a dark car, see what these drugs were? So those are two things that were not obviously in the police report, but when you get these hours of body cam, it's easy to just kind of glaze over them and to, watch them halfway while you're doing something else. But there can be crucial nuggets in there that help you win these cases.
Yeah, and you have to know. I mean, this is the difficulty, right? Is if you don't have a trained eye, it's not going to be meaningful to you necessarily. I mean, some people I think would be able to intuit like, oh, these things are contradictory, so I can bring them up as like to kind of impeach the credibility of the witness. But and then even just deploying that mechanically at the hearing is a whole separate issue. So that was the Somerville case. Do you want to talk about the Boston one, or do you want to move into maybe a discussion of long jurisprudence, or what do you want to do?
So we can talk about the Boston case briefly, because I do think it's a little bit different and kind of interesting. In that case, there was a road rage incident where the other driver claimed that our client pulled out a gun or mentioned a gun and said some sort of phrase about the gun, or something that implied that they had a gun. Police come up and stop her, and they start immediately searching through her motorcycle, and they go through everything, and eventually they find a gun in there. So our argument there was that when they claimed to do this inventory search, that they weren't actually doing an inventory search, because the officers actually, when you do an inventory search, you're supposed to look through a car and sort of determine what's in there so that you can protect yourself from later claims that somebody stole your property, right? So the police are documenting everything in the car. But we had the body cam on that. And when police were supposedly documenting what was in that motorcycle, they didn't note things like her cell phone, her computer, things like that. So our argument was they aren't doing an inventory search, they're doing a search for evidence. I mean, there are other issues in that too. This was another out-of-state resident who was traveling through Massachusetts. She told them that she had a gun, and the police said, oh, well, we got her. That's a crime. Well, it's actually not to have a gun and travel across state lines, because there's the federal safe harbor that allows, in certain circumstances, people to travel with firearms, even in states that they aren't allowed. So we were able to get into that too, that just having the gun is not enough to arrest her. There could be other reasons, things like that. So, I mean, this was another case where looking through the body cam and really having an organized presentation of that body cam and looking through every little nugget with it really helped us.
So two things I want to draw to that. The inventory search you kind of touched on. When did they get to do that? When do police get to just say, I'm going to go through your car now, or I'm going to rifle through your motorcycle?
I mean, it's one of my biggest things. Like, I think I sat through, when I was touring law schools, I sat through a class where the professor talked about it, and it's like stuck with me ever since. It's the idea is that if police take custody of your car, then they should look through it and determine what's in it so that they can document it to protect themselves. So you can't say, hey, you took my pot of gold that was in the back seat. It's like, no, you didn't have a pot of gold because it's not on this inventory list. I mean, leaving aside for the second that not having it on the inventory list doesn't actually help their case, because they can say, yeah, it's not on the inventory list, and you can just as easily say, well, yeah, that's because you stole it and you decided not to put it on there. Like, so it doesn't actually solve the problem. So but leaving that aside for a second, the idea that they are documenting what's in the car, documenting the condition of the car, things like that, and after they take possession of it, that's the idea behind it. But it's just been one of those sort of administrative creations that has swallowed the rule. Like, almost every search we have now is an inventory search. That's the exception they claim. They never claim probable cause. They never say, hey, we saw something in your car, we claim we can search it. They always claim it's an inventory search. And there are policies they have to abide by. Each police department has their own policies that most of the time they don't abide by. So that's another thing you really have to look at, is look at these specific policies. And it can come down to something as simple as, was the car legally parked? Like, I had one of these where we were arguing back and forth about whether this sign that said construction area, no parking between these two times, meant parking was allowed outside of those times. So it can come down to, like, can you park in this area? So it gets into the area of parking law that I'm very interested in as well.
We're definitely going to spend the next hour or two talking about local parking jurisdiction restrictions. No, I
actually won a ticket against the city of Salem, which I'm very proud of. But then I got one again today. I think they're after me.
Yeah, you've won. They're coming after you in a big way. The other thing I think that people are probably waiting for us to talk about is the federal safe harbor that you kind of name dropped. You mentioned the federal safe harbor for people who are traveling, and that there are certain circumstances where when you're traveling through the state, you're covered. And I think people are going to want to know what are those circumstances? What does this look like? What protection do I have?
So the federal safe harbor, basically the idea is that if you are traveling from one state where you legally have a gun and the other state where you can legally have a gun, so it could be two states where you're licensed, it could be two states where they don't require a license and they have constitutional carry, then you are allowed to transport the gun and ammunition. Like I said, you want to look at the law itself and consider this as I can't give you legal advice about your specific situation, but the broad parameters are that the gun has to be inaccessible to the passenger area, locked, and the ammunition has to be kept separate from it. So unloaded, ammunition kept separate, traveling from one state to another where you're legally authorized to have a gun. But we do have a blog about this as well as a video if somebody wants to look at it, if we want to link that in the description. When police search your house, generally there's going to be a search warrant or there's going to be some sort of exigent circumstances you also want to look at to see whether the police had reason to go into your house and reason to search the place that they were searching. The person search we kind of talked about a little bit with the Terry Pat and with the reasons for the stop as well. But we have a video and a blog about this as well that may be helpful to look at if you're curious. But basically, it's this unique proposition in Massachusetts where if you are stopped or searched because of your race, so if there's a racially discriminatory reason for the stop or search or any police conduct. So like I have one right now where we're potentially challenging the police use of wiretaps in racially motivated ways. And the idea is that can be an independent ground for suppression. So even if police did everything legal and by the book, supposedly, as far as stopping you, searching your car, all of that, if they stopped you or searched you and your race played a role in that, then you could be entitled to suppress the evidence based on that as well.
Yeah, that's a really involved and not particularly well understood and kind of still evolving thing. Like that's only been the last, I don't even remember when Lowell came out, 6 years, less. I mean, it's fairly recent stuff. So blog, any posts we have on it, that's the place to go for that. But it is good to know that that's a justification for undermining a stop.
Yeah, and like this is one area where there are all these statisticians that I love them. Like I talk to them and it's like, but they look at the officer's history and determine whether there's a history of this officer stopping people of a certain race more often. It's like intent, right? You can't look into someone's mind and see the reason why they stopped this person, but the statistics can go into that. So you get like math involved. So all the lawyers out there who love math and all of that can have some fun.
No, I mean, honestly, to nerd out briefly on that, one of the things that caught my attention in one of the cases you have that I've helped you work on is what is outsized enforcement racially? What is it based on, right? If you are only patrolling one area and the racial composition of that area is X and your stop is X plus 10, well, now it looks like it's out of scope. But if your patrol area is different, or if the location where the stop occurs has a different racial demographic, I guess the thing to kind of communicate to people is that it gets extremely complicated very quickly. It's like and where it's so new and not particularly well understood, it is a challenging thing for an experienced attorney to navigate. And I think trying to do it yourself would be you need a lot of firepower for something like this.
Yeah, because I read these these analyses by these experts, these statisticians. And they not only have the letters in math, they have Greek letters. So that's how complicated it is. I stopped at the letters. I thought that was complicated enough when you started to have letters. When you have Greek letters, whew.
Forget about it. Yeah, this might as well be in Greek. So do you want to move on from suppression into maybe the federal safe harbor is a good jumping off point for motions to dismiss, right? Because if you had that, maybe I'm wrong about the application, but if you were going to make a safe harbor argument, that's not necessarily going to be a function of suppression, right? You're going to say it's a motion to dismiss because of the law, So why don't you want to talk about that?
Yeah, so a motion to dismiss generally is when you look at the police report and you say, even if you look at the police report and give the Commonwealth all benefits of the doubt, the prosecutor all the ties, supposedly, then they can't make probable cause to arrest. So probable cause is very low standard, and then you give them all the benefits of the doubt. Motion to dismiss, I mean, the usual ground is what they call Di Benedetto or McCarthy are the two cases that deal with it. Di Benedetto is district court, McCarthy is superior. But if there's not any evidence, real evidence of possession. So a lot of times this comes down to the common situation is police stop a car, it has like 6 people in it, they get everyone out, and they find a gun on the back seat. And if they charge the driver with that, then you could possibly have a ground to dismiss that charge before you even get to the suppression issue, before you even get to trial. I can tell you it's pretty difficult to win these cases. Like even in cases where I felt very good going into a jury trial, I filed a motion to dismiss and we haven't been successful just because of how tough they are to win. And you can also dismiss on constitutional grounds. It can be tough to insert new facts into the record in this situation. So like if the federal safe harbor may not be a good example because you have to show where this person was coming from and going to, right? To do that. And that's usually not in the police report. But also other constitutional grounds, like, when we're talking about the Second Amendment, things like that. You can't just go in and say, shall not be infringed, I win. But there could be other constitutional grounds coming up. Like, the Bruen case really changed the landscape on this. Like, I'm going to continue to say it is that before that case, there was no right to carry guns in Massachusetts. There was a case in Massachusetts that basically said it's a rational basis test because Massachusetts does not recognize the right to carry a gun at all. But could be constitutional grounds as well involved in that. But usually when you're talking motion to dismiss, you're talking about there's just no evidence whatsoever of possession.
Yeah, I think your point about the safe harbor is well taken. I don't know if people would necessarily know exactly why your point is, and I think maybe I'm reading maybe too much into it, but to insert facts would require the testimony potentially of the client. Right, you have to have the client essentially testify, I was traveling through, and then you subject them to cross-examination by a prosecutor, so it can be hard to establish. And then motions to dismiss are typically not evidentiary, so you have like a whole separate issue to deal with. But we're getting way into the weeds on that one.
Yeah.
Do you want to talk about your trials? You think that's a good place to jump to at this point? We talked about motions to suppress. We talked about motions to dismiss. If you can't prevail at any of those stages, you got to try the case if you're not going to get a breakdown. And that really, we talked about this at the outset. If pleading guilty means a judge has no choice and will sentence you to 1.5 years in jail, and you will do every day of that 1.5 years, there are going to be circumstances, obviously, that change the calculus for everybody. But in a lot of times, it's going to push people to say, well, I should at least just try it. If you don't have a record and you were just passing through, and you're caught in kind of a bad situation because the laws are written the way they are, try your case. Do you want to talk Chelsea? You want to talk Lowell?
Yeah, so we can talk about, so if you don't have any other options, sometimes you just have to go to trial. And it's always a difficult thing. People call it, taking it to the box, because it's literally like you are putting everything on the line. I always tell people, like, if you may walk in the good door in the courtroom and walk out the bad door in the courtroom. Like, it's putting everything in the hands of 6 people in district court, 12 people in superior court. I mean, we just had 2 cases that were pretty big wins for the firm over the past, both of them in August, that really show the benefit of going to trial and really show the benefit of, hey, take these cases that you think are losers and you never know what a jury's going to do. Not to say, obviously, like, when I say loser, I mean a very difficult case for us to win. But sometimes when your back is up against the wall, that's the only thing you can do. And sometimes you succeed at it. Like the one we just had in Essex Superior was a client who was originally from New Hampshire. He bought a gun in New Hampshire. He was arrested on an unrelated charge. And then the police, when he was in his jail cell, asked him about a gun. And he asked him about a gun they found in his car, suspected him of having in his car. But they tricked him into getting there, right? So they gave him his Miranda rights, which, we've all seen on TV, you have the right to remain silent. When they told him, but we're not investigating your case. We're just asking you booking questions, basically. So he thought, hey, these people, I've got to cooperate with them. They're just doing their job, filling out paperwork, all of that kind of stuff. But then at some point that changed. At some point they said, you know what, we want to investigate this gun. So what we're going to do is go ask him about living in New Hampshire and try to lower his guard down and then ask him about this gun. And he admitted to it. He said, yeah, the gun, it's in the glove box. The box is in the trunk. that's where you'll find it. And they said, it's your gun? Yep, it's my gun. And they even asked him like what kind of gun it was. There was a discrepancy in there that we caught during the trial. And I, in my opening statement, told the jury, I'm going to ask you to ignore what he said. I'm going to ask you not to consider it. And it's one of them
laughed at you, right? Yeah. They were like, you want me to ignore some of the evidence?
Yeah. So, and one of the jurors on that case is the only time I've ever had somebody without a poker face. And she looked at me like, what? It's like she literally did that look. But because what I'm asking is there's this concept in Massachusetts called the humane practice or voluntariness, where you can actually, the jury can actually decide to suppress something. A defendant's statement, the jury can decide to suppress it. And I said, hey, because they tricked him, I'm asking you to throw that out. And there was also an issue there's another exception to the gun laws, and there's a series of these exceptions that apply to very specific situations. One of them is if you're a new resident in Massachusetts, you have 60 days to get a license to carry. So you can bring guns from out of state into state if you're moving in and you have 60 days. There are a lot of restrictions to it, and make sure that you consult with an attorney if you are thinking about this. But we also argued that. And the jury agreed and acquitted him. So even though he admitted to the gun, the jury acquitted him and he avoided the 18 months. He avoided any jail whatsoever on that case.
And the crazy thing, just to kind of summarize two of the more impressive things about this for me, that, I mean, one, I guess we won't ever know whether they bought on voluntariness or the failure of the Commonwealth to provide any real evidence about the residency exception or the timeline thing there. He admitted the gun was his. And you were able to prevail at trial. Like this usually, again, having been a prosecutor, if you have a confession that's backed up with some physical evidence, it doesn't really get a lot better than that. Earlier in this podcast, we said you don't usually know what's in a person's mind, right? You can't prove knowledge. You can't prove intent unless it's like, yeah, that's my gun. Here's where you can go find it. And I mean, poor guy, he's saying this because he thinks these are routine questions. He doesn't think he's being set up to walk into a 10A charge. And so it's a great example of, even when it may seem hopeless, if you have someone who knows how to handle these cases and can work every possible angle, you can get some measure of justice. And I think in that case, I mean, yeah, that guy might have walked out the wrong door for a year and a half, but you were able to convince a jury otherwise. Do you have anything else you want to talk about with that case?
No, I mean, that was, well, just briefly, like this guy was, a father. I mean, you think about if you forget to renew your registration, or if like some people on their podcast forget to renew their license to carry. And I think we talked about that before, but if you...
I don't know what you're talking about. I'm a very careful bookkeeper.
So, I mean, things like that, it's like a paperwork issue. Like you did not go down to the police station to fill out this application, even though you likely would have been approved, and that cost you 18 months. So this guy, I mean, we were so lucky to get the jury we had. We were so lucky that the evidence came in the way it did. Because, I mean, we prepared for him to go to jail in that case, and he walks out.
Yeah, it's a heck of a result. What's the other case you want to talk about?
So the one in Lowell we just won was another one that was, I mean, that involved pretty much everything. Facts of that case are, we're getting into war story time here. Police get called for supposedly a robbery in progress. This guy's like, hey, these people are coming to kill me and rob me with a gun. When they come to the apartment complex, they see our guy carrying a crossbody bag, like a shoulder bag, a messenger bag, I think is what you sometimes hear it called. They stop him, start asking him questions. They start patting him down. They don't find anything. They sit around for about 20 minutes or so. And then someone's like, hey, did we pat down his bag? And they're like, no, we forgot to do that. So they do it. And sure enough, they find a gun in it. And according to the police, they did not have body cams in that case. But according to them, they said that he was sitting on the bag. He would definitely know that there was a gun in the bag. But the other fact that we had going for us in that case was that there was another guy on scene his ID and everything was inside of the bag. And we were able to kind of weave this story where even though this guy was carrying this bag with a gun in it, we're able to show them that, hey, he may not have known that there was a gun in there. It may have belonged to the guy whose ID was in the bag. I mean, think about your ID. Like that's something you usually know where it is at all times. You don't hand an ID to somebody else and say, hey, put this in your bag for me. So we were able to convince a jury that, yeah, he wasn't in possession of that gun, even though he was carrying the bag and sitting on it. We also litigated a motion to suppress in that case, and were able to get out some of the statements that he made, our client, but we weren't successful in suppressing the actual bag. But it was immensely helpful because we got all of these officers on the stand. We were able to cross-examine them. We were able to establish timeline. We were able to basically, I was able to know what they were going to say before the trial so that I could build my defense around that. I mean, this was a team effort. Like our intern, our co-op student, Xander, was instrumental in both of these cases with just like putting everything together, brainstorming with me, all that sort of thing, as well as like it was a team effort with everybody. You and Bill really helped go through these cases with me and kind of brainstorm about different things we could do. But again, this kid was in his 20s. He was a college student from out of state, had a great family, and he was facing 18 months in jail if he was convicted. And we were able to walk him out the right door of the courtroom.
Again, and this is where he's sitting on the bag. You got a constructive possession argument built in there, and that may have been what saves the day, right? And having had to prosecute constructive possession cases, it can be tricky to say, how would you know to a certainty that the person knows the identity of the object while he was sitting on it? Maybe that's inadequate. And I think one thing that was going through my head while you were describing this is a lot of this goes back to first principles as criminal trial attorneys, which is that the government bears the burden of proving every element of an offense beyond a reasonable doubt. This isn't I say this and you say that. It can be hard to win cases when the facts are this rough. But if you have an attorney who knows what they're doing, who has had experience in trial, they know how to point out where the government hasn't carried its burden and can provide like scenarios or countervailing theories that it will be that kernel of reasonable doubt that a jury needs to latch onto to say, you know what, I don't know that I can buy this. I'm not going to convict this person on the basis of what you've shown me. And so,
yeah. And I actually stole this from another attorney. I watched a closing and he describes it as being, you got to be damn sure is what beyond a reasonable doubt is. Like, you can't just be kind of sure. You got to be damn sure. Like, this is a sort of certainty that some cases talk about that you act on without hesitation in the important decisions in your life. Like if your kid was having surgery, you wouldn't just say, well, I mean, I'm kind of sure that this will be okay for him. Like I want to talk to the doctor. I want to talk to the doctor's doctor. I want to like look it up on Google, all of that kind of stuff. I want to be really sure before I make that sort of decision. It's the same thing with this because you can't prove your innocence. Like he can't prove, there's no video evidence that he didn't know the gun was there. So they have to prove that he did. And it's part of the beauty of our system.
Yeah. And I mean, I think there are probably a lot of people out there who are thinking like, well, I mean, I could prove it. Just let me testify. And that came up in the first trial we talked about. I remember the client asked you if he could he said he prepared himself to testify, right? And the problem is that as a former prosecutor, I can tell you that's not a good idea. And I know that as a long-term defense attorney, you would say it's not a good idea because you put yourself at the mercy of someone who investigates things for a living and does trial work, probably for a living. And the ways in which you could be discredited or he turns into a popularity contest and the jury thinks you're a bad guy. So you can't prove your innocence, right? You said that? People probably believe I could prove my innocence. I just got to testify.
Well, I've always wanted to use this in a closing argument, and I've thought about it because there's this meme where they say somebody was delivering something and they say, can you prove that it wasn't delivered? And can you show us a picture of it not being delivered? It's like, right. And the guy sends a picture back of his like empty hand. He's like, I don't have it. But think about what it would actually take to prove that it wasn't delivered. Like you would have to show camera footage consistently of all around your house to show that no one approached with it. And if someone approached with a box, that box did not contain what it is. So that's how you have to prove that it wasn't delivered. But to prove it was delivered, all you have to show is one picture of the box next to your door. So that's why we have a burden of proof. Like these are the sorts of things that, we talked earlier about all the exceptions, which are very narrow. One sort of exception to the 10A requirements, having a license in Massachusetts, for example, one of them is if you're instructing somebody, obviously every single gun shop and every single firearm school would go down. It's because like you're required to have live fire now. You handed somebody a gun, they don't have a license to carry because they're taking the safety course, obviously, like, that's not going to be a violation. So, like, if you're instructing somebody and you're under the supervision of somebody with a license to carry, that's one exception. But there are plenty of others in the statute. One of the other big ones that's come up for me, though, is an antique firearm. So, like, you also have the black powder, things like that, but a gun manufactured in 1899 and prior. And you might think 1899, that was 26 years ago. There's no way there are any guns around still. That was some quick math there.
I'm really very impressed.
But actually, I've had this come up, and I will always remember what this gun looks like, because I looked at it and I was like, that gun seems like I've never seen a gun like that before. And it wasn't like a flintlock musket. It looked like a regular pistol. And I hired an expert, and the expert looked at the gun and he said, this is an antique. It was like manufactured in Springfield in like the 1860s. And it was like a chrome handgun. You wouldn't know it from looking at it. So that's something from then on, I always talk to my expert, G&G Firearms, Greg Danis in Lowell. Hopefully he'll be on the podcast soon with me. But cool. He looked at this serial number of this gun, and he said the trooper who analyzed it thought this A was a 4, but it's actually an A, which means that it was manufactured in this, like, at this time. And he had this like old book that he like brought off of his shelf that he dusted off and all this stuff that said when this gun was manufactured. So antique firearms is one example that I always look at, and unless you can really tell, but even then you never know if it's not a working firearm. So like, I've also had that situation. So this is one of those things that they changed in 2024, that they don't actually have to prove that the gun fires.
Disrupting the ballistician industry in a big way.
Yeah. So they have like this, usually the state trooper will come down and get every single gun in these cases, put a bullet in it, and fire it into this huge water tank. Sometimes you'll notice this on the report, sometimes not, that they'll say we had to make small repairs to the gun in order to get it to fire. And there's this whole law about what kind of repairs they can make to the gun so it can still be considered a working firearm. So that's another thing you want to look at is it a working firearm? And a lot of times what I do in these cases is I file a motion that says, listen, if you want to test this gun, I want my expert there. And if before you do any alterations to the gun whatsoever, I want to be there and I want my expert there so that we can observe it. Because these aren't recorded in any way.
I mean, the other thing that's worth bringing up, and I know people have strong feelings about this, but they changed the definition of firearm last year to include a lot of things that people would not recognize as firearms. I did not write the law. As far as I know, Matthew, you did not write the law.
I did not.
You know, and I mean, this isn't legal advice. It's a podcast, but you want to consult with a lawyer if you've got parts of a firearm that you think this isn't a complete firearm. The state of the law would confound you, and so I think it's worth talking to an expert, or at least someone who could give you good legal advice about whether your lower receiver, absent any other parts or equipment, could be charged as possession of a firearm. Because again, I'm not speaking to the merits of this law, but I'm telling you that the way that the law changed is pretty astounding. So be current, be aware.
Yeah, and I mean, taser, like these things that are $20 that you buy on Amazon in any other state could still be considered a firearm, but in a lot of cases are not anymore based on a court ruling out of this. But things like that, like I've defended clients 18 months for having something they bought for $15 on Amazon. I mean, it's absolutely ridiculous. Like, and I'm sure we'll get comments like last time about how, we're not sufficiently versed on the Second Amendment. It's like, listen, man, you can talk about the Second Amendment all you want, but when you're talking to me through a jail cell, like you're gonna want to know what the law is and how we beat this thing. 26
words if you count a hyphenate as a single word, 27 if you don't. It's the shortest right enshrined in the Bill of Rights. I am fairly well familiar with the thing, and we live in Massachusetts. The law is what it is, so we don't have any say over how it's written. I mean, besides our ability to vote for legislators and that sort of thing. And
yeah,
I mean, our role is way scaled back from that. We're in a reactive posture. Clients come to us when sometimes I'll say this, we get calls from people who want advice prospectively. I had a call with a young person who was like, I'm worried that if I get caught with this thing, I'm going to be in a lot of trouble. And what do I do to turn it in? And I talked to him about, the laws governing the turning in policies and stuff like that. And I mean, a proactive approach can be a lot better than having to triage at, when police have violated your constitutional rights, but now you're charged. And I mean, we don't even have to get into dangerousness hearings, but it is sort of like reflexive, right? If you catch a gun charge, they're going to try and have you held, right?
Yeah, and I just actually wrote a blog and did a recording about dangerousness hearings and guns. If any sort of gun charge is a dangerousness predicate, and there are some ADA or some DA's offices in this state who have a policy that says that any gun charge they move for dangerousness. In every one of those cases I told you about earlier, the Commonwealth moved for dangerousness.
Can you remind our audience how long you get held for on a dangerousness hold?
So 120 days in district court, 180 in superior. That can also be extended. And there's a whole other, like we should do another podcast on dangerousness, because it's another one of my things that it's just.
I want to get you up on a soapbox, Matthew. That's a big one.
Yeah, it'll be after our parking podcast. Parking regulations.
Oh yeah, municipal parking violations and how to overcome them. Do you want to talk about Guadardo at all, or is that a separate podcast? You just want to tell people we probably have material on that on the website.
Yeah, so we do. So Guadardo is the case out of, I think it was 2021, 2022. It was right after Bruen. I actually remember what courtroom I was sitting in, and if I thought about it when I read it. It says basically that it used to be that having a license was an affirmative defense, and this sounds crazy right now. So they could charge you with possessing a firearm without a license, and they did not have to prove you did not have a license. So that was a law prior to this. And then the SJC said, actually, you do have to prove, because we can no longer assume that all guns are illegal in the Commonwealth of Massachusetts. So the Commonwealth actually has to prove you don't have a license. So there's this like cottage industry of these experts from this organization called DCJIS, the Department of Criminal Justice Information Services, which is different from the database. It's called CJIS, that go around and they say, yes, I searched this person by their name and their date of birth, and they did not have a license to carry. They come in and testify only to that. But hey, like the one I had in the last two cases with this like retired major from the state police, it must be a pretty cushy job. Like, I don't know. Like you basically just search something and you go in and say, hey, yeah, I searched this and this is what I found.
Yeah. I know people who work in the prosecution field still, obviously, and they say that Guadardo was the court tacking on an element to possession, which is why I thought it would be a worthwhile thing to add, since we talked about the elements of possession. So
yeah, like they have to.
Yeah.
And it's a tricky thing to prove. When you get in trouble is when the Commonwealth, some particular prosecutors will do this. They'll say, oh, I don't want to prove that you don't have a license, but I'll prove that you have a prior felony conviction, which means you couldn't get a license. It's like, I don't really want the jury to know my guy had a prior felony conviction, so I'll just stipulate to that. So yeah. A lot of times that it's kind of created this whole thing after it, Guadardo, but I mean, it's at least good that we've moved into guns are not per se illegal in Massachusetts.
Slow progress, but progress, I guess, in some form or another. And maybe that's a good place for us to end, unless you have any parting thoughts for the viewers. I have a couple of things I want to make sure that folks who have any, questions, we want to know what parts of this are unclear, if there are things you want to hear more about, if there's certain things you'd like topics you want to see expanded on. The purpose of this is to kind of help educate folks on the status of some of the laws here, and to let you know there are ways to fight, even if you don't, you're caught up in a bad situation. So if there are things that you think would be helpful to be clarified, let us know, and we'll try to address what we can, see what we can, what information we can provide to you guys.
Yeah, thanks for having me on, Chris.
Matthew, always a pleasure. Congratulations too on your recent wins in court, huge victories on gun charges. And I know that your clients, these two people who would have done a year and a half each at least, are back with their families. And I think I'll call that justice for sure.
Oh yeah.
Until next time, Boston Barristers, Law Office of Matthew W. Peterson. I'm Chris O'Brien. Thank you for being here.
Yeah, thanks, Chris. And if you guys have any comments, interesting reactions, we're going to try to post a lot of the blogs that we refer to in there. But obviously, if we're missing something, comment and let us know. Or if you have some insight or an area of expansion that we want to talk about, let us know.